Welcome to our vibrant network of governance, risk, compliance, and cybersecurity leaders. We share cutting-edge insights, best practices, and innovative strategies to empower professionals in navigating the dynamic cyber threat landscape. Join Circolo de CISO to ignite resilience and data protection across industries.
This is going to be our 7th episode, not the edition, 7th episode, where we are going to talk about international perspectives and harmonization with respect to AI and intellectual property. So, Thanuki, the question is, are there significant differences in how different countries approach AI and intellectual property? How do you see this?
Well, the short answer is yes, and that will always be the case when it comes to laws, regulations globally, because different regions, different countries have very specific requirements, and laws are usually localized to cater to those requirements. But that being said, if I take like three major blocks of this conversation, if you take the EU and the US and China, they have unique approaches to AI, copyright, etc. But they do have certain commonalities as well. Like, for example, they recognize AI-generated works as copyrightable to a certain extent, right? And there is this common understanding of a requirement of human involvement, and that you need to show this human involvement in order to get copyright protection. In the same way, when they talk about patents, inventorship, there has to be a human element, and this is like something that is running like a golden thread in the conversations across these three regions or country blocks. So they all grant copyright owners the exclusive rights to reproduce, publicly display, distribute, and perform their works. And they also provide exceptions for fair use or public interest purpose. And that's there. But the differences that are there, if you take the EU has a copyright directive, and there it talks about a AI system, granting AI systems a sui generis database right. So sui generis means to each his own, kind of like specific to that particular kind of thing. So they recognize that unique nature of whatever it is that. So basically, the AI systems are considered a sui generis database rights holder, a distinctive approach that is not adopted by the US or China. So the EU also, I know, offers very detailed guidelines on fair use and exceptions, including a specific text and data mining exception also for scientific research. The US, on the other hand, they don't have specific legislation for AI-generated works. So what they do is the existing copyright laws, that is what is being applied, and they have a lot of case law that is popping up across the United States at the moment, because there's so much going on in the copyright space, very significant cases. And that is what is kind of informing the way they view this whole intellectual property rights dialogue. But at the same time, the US has a very broad fair use doctrine. So that accommodates a lot of uses like parody and criticism and news reporting, etc. In China, the copyright law does extend some protections to AI-generated works, but there is lack of clarity when it comes to ownership and fair use in AI research, right? And they also have difficulties when it comes to enforcement and high cost of legal proceedings. So each region's approach, of course, it's unique. There are different priorities, and that is what gets reflected in terms of the laws. But as I told you, there you have the commonalities as well. And well, we're yet to see what's going to happen in the near future with all of this.
So the question is, which way is it tilting? Are there more commonalities or there are more disparities?
At the moment, I think there's more commonalities than there are differences.
Okay.
Because See, the IP legal frameworks were put in place long before this generative AI aspects even came into place and kind of blew up, right?
Mm-hmm.
So the IP laws at the moment are still far behind. So whatever they're doing, they need to adjust. So they're going on this basis of this human element, and that is going to remain that way for a while.
Mm-hmm.
So I guess once there are any changes to that, once they decide, okay, we want to consider um, AI systems as entities all by themselves, like how in company law, how we would consider a company as a legal entity. Similar to that, if there is a day where that kind of conversation comes up, then I would think yes, then these laws are going to change. But at the moment, there is a common thread that runs across regions when it comes to the IP legal framework.
So, Thanuki, while we are talking about differences and commonalities, would there be a day where we would see harmonization across countries? Because right now we've only spoken about EU, then we've spoken about US and China. And there are so many other countries, right? I mean, we're
Yeah,
typically talking about 190 plus countries, and each have their laws localized,
yeah.
right? Of course, we have the common laws, and then we have the international courts and all those things, right? So for dispute resolution. But as the world converges, do we see the laws converging?
I do think that is a possibility uh, in the near future, because there is a lot of conversation surrounding these aspects, especially to do with inventorship, authorship, ownership, and a lot of conversation around whether we should be creating a new sui generis of its own kind of IP right for AI generated inventions and works. And there's a lot of conversation around that. So obviously at some point we can expect that these conversations will lead to some sort of tangible efforts to harmonize all of this. Now when it comes to harmonizing intellectual property protection and enforcement and creating international standards, you have this agreement called the TRIPS agreement, trade related aspects of intellectual property rights, and that is a 1994 agreement, if I'm not mistaken. So we are yet to see how things like something like that is going to embrace artificial intelligence and the kind of changes it is creating in the intellectual property ecosystem, and whether it's going to kind of take that on and address it. But certainly there's a lot of conversation, and if you kind of pay attention to some of the work that the WIPO, World Intellectual Property Organization, is doing, almost on a monthly basis, they have massive conferences, programs where they get in people from all parts of the world together, and they talk about very specific concepts pertaining to generative AI, because it's a valid concern. So yeah, I do think that all of this is going to eventually come down to something that will address the concerns of everybody in a harmonized way, and that can definitely be expected.
Thank you, Tanuki, for sharing those thoughts on harmonization and international perspectives. So, viewers, I would only hope, right? I mean, if we had a pause button so we could pause everything, set everything right, and then restart again. But that's not the reality. The reality is that the laws are evolving. They're trying to understand where to draw the line and what should be in the ambit. While we are talking about the laws, the innovation are also accelerating. And maybe the technology is innovated for one purpose, but eventually when people start using it, they could use it in different ways. So with that thought, thank you, Tanuki, again for sharing your views in this episode. So I invite our viewers to look out for our next episode, which is going to be on enforcement, challenges, and solutions. See you around.